Given the circumstances, at least as I understand them, and because I haven't heard the entirety of the case or anything,
Right, exactly.
I'm
Probable cause or anything.
going to deny your request. Bond, continue.
Why?
Excuse me? Excuse me?
Right out the gate, we've got fireworks. The defendant loses his temper instantly after the judge denies his request. And this isn't just a small outburst, it's an early red flag. Judges maintain control of the courtroom. And when a defendant interrupts or challenges that authority, especially with this level of aggression, things escalate fast. Now here's what makes this moment so tense. The defendant is choosing to represent himself, which puts him in direct conflict with the court structure. Self-representation is a legal right, but it's also a high-risk move, especially in criminal cases like this. Judge Simpson doesn't just warn him, he makes it crystal clear, act out again, and jail is waiting.
Sir, we're going to have a real problem if you're going to act like that in this court. I want to make it real clear. I understand you want to represent yourself. I told you I'm going to hold you to the same standards. You will not, by motion, by anything you say, disrespect anything in this court. You understand me? If there is another outburst during any of these proceedings like that in regard to my rulings, I will give you a place to stay. You do not have to worry about having a tether. Am I clear? Am I clear?
Sure.
Court does call the case. The people of the state of Michigan versus Cody Lee Jolly.
Here we go. The official case begins. And it's time to pay attention. We now know the defendant's name, Cody Lee. That name might sound ordinary, but what follows is anything but. What's fascinating here is how calm everything sounds after that fiery intro. But don't be fooled. This quiet moment is the calm before a legal storm. Judge Simpson is about to reveal the charges, and when we say serious, we mean life-changing. Let's also note something strategic here. The judge immediately verifies whether Mr. Lee still wants to represent himself. Why? Because the court needs it on record that he understands the risks. And trust us, the risks are massive. This moment sets the entire tone of the hearing. High stakes, legal complexity, and a defendant who thinks he can outplay the system.
We're actually set for, what are we set for? Yeah, we're set for PCC. All right, state your name, sir.
Cody Lee Jolly.
All right. Mr. Jolly, are you still intending upon representing yourself? All right. I do have to apprise you that in this matter, you were charged with 2 offenses versus criminal sexual conduct in the 4th degree. Well, 2 counts as criminal sexual conduct in the 4th degree. You understand the nature of those charges? You understand the allegations as explained to you during the course of the arraignment in these cases?
And there it is. 2 counts of criminal sexual conduct in the 4th degree. These are not light charges. CSC 4 in Michigan is a high court misdemeanor. Technically not a felony, but the consequences can still be devastating. What's wild is how nonchalant the defendant seems here. No visible reaction, no objections, almost like he's either in denial or doesn't fully grasp the gravity of what's happening. Judge Simpson lays it all out clearly. Possible 2 years in jail, a $500 fine, mandatory STD testing. But here's the real kicker. Even if you serve less time, the social damage from a CSC charge doesn't go away. Jobs, relationships, reputation, gone. Would you trust someone to represent themselves on charges this serious? Or should the court force representation in some cases? Let us know in the comments.
Okay. The maximum penalty, those are both high court misdemeanors punishable by up to 2 years incarceration, $500 fine plus court costs, mandatory STD testing. You understand that, sir?
Yeah.
All right. You understand that there can be great peril in attempting to try to represent yourself in a criminal matter of this nature? And you understand that the court would hold you to the same standards as I would any licensed attorney in terms of court rules and in terms of court procedure. You understand that?
This is a crucial legal reminder. If you represent yourself, the judge will not cut you any slack. No hand-holding, no second chances. Judge Simpson emphasizes it multiple times. You'll be held to the exact same standard as a trained lawyer. That includes court procedures, motion filings, evidentiary rules, everything. And if you mess up, you're done. It's a huge warning sign when a defendant says, "I want a trial," without even understanding that this isn't the trial phase yet. We're still in pre-trial. There's a whole ladder of legal steps before we even get to a jury. This commentary may sound harsh, but it's necessary. Cody's legal knowledge is clearly not up to par, and that puts him at a massive disadvantage in a system that thrives on procedure and precision.
You understand that the court is not going to try to assist you or help you out in any way? All right. And you understand also, sir, that if you are indigent and cannot afford to hire an attorney, that you would be afforded counsel and could request counsel at any particular time. You understand that?
Yeah.
Okay, very good. All right. So what are we going to do in this case?
Your Honor, I'm covering this case for Ms. Reiser today. She did provide me with the outstanding CD of discovery for the defendant. I understand that the police report has already been sent out to him by mail. And the CD provided to the jail staff.
Yeah.
If the answer is no, I don't sort of have that. Could you put it in? Is that acceptable? Is that okay with you guys? Okay, thank you so much.
All right.
So that's
Oh.
everything we have.
All right. That's all discovery. Sir, what did you want to do next on this case?
Before I start the trial.
Well, you understand that the next step is not that of a trial?
Is this pre-trial?
Oh, okay.
I understand this is pre-trial and we're on the trial.
Mr. Jolly, do you really wish to represent yourself in this matter? I'm a little bit concerned because you don't. Well, but that's not how it works. Okay? That's what concerns me. You're charged with a high court misdemeanor. Okay? The next step is that we're at a probable cause conference. The next step is a preliminary examination. Okay? And then if you're bound over, then you're going to go through that process once again on the circuit court level. You follow that? Okay, so now understanding that that's a basic procedure, what do you want to do?
Just move forward and just not guilty and case get what preliminary examinations. Okay. I have this matter I'm in custody right now. And I was hoping to solve it.
So you want it, you got a copy of the police report, right?
I got the discovery. It was emailed to me.
Okay. So you want a preliminary examination in this matter?
If that's the next step to move on to trial, then I'm trying to get the trial done as fast as possible, but if the preliminary examination goes before that.
Let's break this sentence down. Cody's request for a fast possible examination might sound like he's trying to expedite the process, but the way he phrases it shows confusion. This isn't just a language slip. It reveals a deeper issue. He doesn't fully understand the difference between a preliminary exam and a trial. These aren't interchangeable. The prelim is to determine if there's even enough evidence to move forward. Judge Simpson, to his credit, shows patience, but you can feel his concern growing. Because when a defendant missteps this early in the process, it signals serious problems ahead. Cody is eager, but legally unprepared, and that's a dangerous combo.
Wow. All right. I know, but if it has to break, we just have to break.
Yes, sir.
All right. Set preliminary examination for April 23rd, 2024, 9 a.m. That will be before me. That's in person.
In this matter, the prosecutor goes in.
Pardon?
The other day I went to the arraignment. I was hoping that to get released, but there was, I had to come here first. Can I get released through
What do you mean you?
He was arrested. My office had a new warrant request for him from the University of Michigan. It was for trespass and for violating the conditions of Your Honor's bond and that you said in this file.
Things just got worse. Now we're dealing with bond violations, and not just minor slip-ups. The prosecutor reveals that while out on bond, Cody was reportedly caught again at the University of Michigan, a place he's been trespassed from before. That alone is a huge red flag. But then we hear this: he was allegedly looking at inappropriate images in public, shirt open, pants low, behavior alarming enough that police were called. This isn't just bad optics, it's legally damning. Not only did he return to a restricted area, but his actions suggest a pattern of behavior that could influence the outcome of his current CSC charges. Remember, when you're out on bond, you're on thin ice. Any misstep gives the court more reason to keep you in custody. And this one, it's practically a cannonball through that ice.
Historically, he has been trespassed from the University of Michigan libraries numerous times. He was again there, which is where he was arrested on April 5th, 2024. He was publicly looking at inappropriate photos of women in the school library, and other people were able to see what he was doing. He was reported when the police came. They recognized him. They recognized him as the person that they had trespassed times. The report indicates that his shirt was open, exposing his chest, and that his pants were pulled down, but that his genitalias were not exposed as far as they saw. Certainly this is the CSC. He's out on bond in the CSC case while he's engaging in this behavior. At the very least, the ongoing trespass is violation of his bond, given that he's committing a new crime while he's out on bond, and that concerning behavior engaging in a public place, in a place he's been trespassed. My office denied the warrant request and essentially turned to this case and for us to move forward with a violation here instead.
All right, sir, you are entitled to a hearing regarding a bond violation on this matter.
Judge Simpson now offers a crucial legal fork in the road. Cody can either admit the bond violation or request a hearing. This is one of those moments where every word matters. Why? Because what the judge is really saying is this: if you admit the violation, you could be stuck in jail. If you fight it with a hearing, even with slim odds, you at least get a chance to argue your side. But here's the twist. Cody immediately admits to being back on campus. He tries to justify it, but in legal terms, that's an admission, and it puts the judge in a tough position. Do you think he even realizes what he just admitted to? Or is he playing down the danger of his own words? Let us know what you think.
Did you want to have a hearing on that? Did you want to admit the violation, or did you want to deny it? What do you wish to do?
To admit the violation was what again? I'm sorry. The violation was because when I got here, they told me that everything was, they said that it was, when they came out and gave me the trespass, when I got here, they said the trespass trespasses and stuff, and they weren't worried about it. It wasn't.
Well, they weren't worried about it from the standpoint of new charges.
Okay, yeah.
But my understanding is that the prosecutor doesn't want you released because what the conduct that's alleged to have occurred is a violation of the condition of bond on this case.
Yeah, there was nothing inappropriate besides being in the library, yeah, no, nothing weird in the public library. I have no idea. But yeah, I wasn't.
But you weren't supposed to be back on on the property.
That's what they said. I guess that was stemming from this. So,
Do you want a hearing on it? Or are you going to admit to the violation? What are you going to do? You're entitled also, sir, to have a representation of an attorney for a bond violation here.
but I mean, if it's not a new charge, I admit that I was trespassing. That I was probably trespassing there. I was hoping to get out of jail for days.
Well, I need you to understand that I'm not agreeing that you're going to get out of jail at all. Whether you admit it, do whatever, I'm not.
Right.
Well, you just admitted to the violation. That's why I'm worried about you not having an attorney. Just, you admit to the violation of being on University of Michigan property, correct? Okay, so that's why I'm worried about you not being represented by an attorney. Because that's a violation of the bond conditions that I set in the case involving the criminal sexual conduct.
Let's zoom in on the strategy here. Cody admits to being back at the university, and Judge Simpson immediately latches onto that, not out of spite, but because it's legally significant. It's not just trespassing, it's breaking the rules of his release. And that's what courts take very seriously. If a judge sets conditions and you violate them, it undermines their authority and increases public risk. This is why bond conditions exist in the first place, to ensure safety and prevent repeat offenses. When those are ignored, the court can't afford leniency. Judge Simpson is signaling that trust has been broken, and once that happens, jail isn't just likely, it's expected.
In a public library, I've never been there before. So I wasn't aware that I wasn't allowed to be in a public library. I've never been in the building before.
Sir, did you want a hearing on the bond violations? Because I'm going to take into account everything that they're indicating, that you were trespassing and what was in there. Do you want a hearing on that?
Yes.
Do you want an attorney to assist you regarding that hearing on the bond violation?
I think I'm okay. I just the bond and stuff, we can get it heard. Simple as that. I've done 10 days in jail already. And
Where are you coming up with this 10 days in jail?
just got out.
Yeah, but what do you mean I've done my 10 days?
I've been 10 days so far, and I've not actually had the charge. I've been charged with these 2 counts that are here, but I've not actually committed the offense.
Okay, but sir, you understand that the criminal charges that are here, that your release on those criminal charges, there were certain conditions regarding your release.
Right, that's what they're telling me.
Correct. In certain places you couldn't go, you couldn't leave the state of Michigan, no alcohol, all of that stuff, right?
The best I can. I've been 2 months without a problem. The best I can.
Okay, but now I have I have a trespassing, which is a violation of the conditional, your release. And I could, if there's a violation of the conditions of your release, I could certainly let you out. I also could just hold you until this matter gets resolved. You understand that? And now you want a hearing on that. And that's fine. I don't have a problem if you have, you're going to have a hearing on it. But then the issue becomes, are you gonna try to handle this hearing yourself? Or are you gonna want an attorney to assist you with that? I understand that you want to move forward, but there's gonna be a hearing that's going to determine whether or not you're in custody. Pardon?
As soon as possible.
Well, I haven't set a date. I'm trying to figure out how you want to proceed on it.
Just like I said, I'm just doing my best to live my.
Sir, I understand all of that. Listen closely to my question. This hearing on the conditional bond violation could determine whether or not you're in custody or you're released with other conditions or not, pending the further proceedings in this case.
This is the turning point. Judge Simpson clearly outlines the stakes. This next hearing could decide whether Cody walks free or stays locked up until trial. There's no ambiguity, no second chances. Either Cody presents a convincing case with or without an attorney, or he faces pre-trial incarceration. Now here's where things get concerning again. Cody seems to be winging it. He doesn't ask for legal aid. He doesn't lay out a strategy. He just says, "I'll handle it." Think about that. Representing yourself in a hearing that could land you in jail indefinitely. Would you take that risk without legal help? Or is this a textbook example of pride overriding good judgment? Sound off in the comments. We want to hear your take.
Bottom line, I could come to the decision, okay, well, I'm gonna let him out, put conditions on you and you walk out. Or I could come to the decision, no, he's gonna be held on this case. I'll give him a bond of some type, but he's gonna be held. Okay, but you understand what I'm saying?
Yeah.
You'd be held. That's what's at stake.
Yeah, just hope to get out as soon as possible. So I just like to move forward.
Well, I understand that, but follow what I'm saying to you. You say you want a hearing. My question to you is, are you going to try to do this hearing yourself, where one side of it, you might get released, the other side of it is you might be locked up for the remainder of this case? Do you want to try to do that yourself, or do you want the assistance of an attorney to help you through that process?
I think I just hope that just facts.
Just answer my question. You're gonna handle it yourself. Okay, but you're going to handle it yourself. How soon could we have witnesses available for a bond violation here?
The answer to that question, I apologize.
No, it's okay.
Are you thinking like a week? Is that what you mean?
I'm thinking sometime next week, and then, because the following week is his, what day?
So we would have Tuesday morning available, but.
The 16th.
But he's in custody, so I would do that. Because that's pretty much he's in custody. Once we did it.
What, I got stuff Tuesday afternoon.
You have an expungement docket at 1, which is small, so you can do it at 2:00.
I could do it at 2:00 on Tuesday, the 16th.
It's a U of M police officer, so I can email him, to U of M police officer, so I can email them and see if one or both of them can be there on that date.
Okay, what I'll do, I'll just set it. If there becomes a problem, we'll communicate with the defendant as well as you, just try to arrange a different time. So set a bond violation hearing, April 16th, 2024 at 2 p.m. At 2 p.m. There anything further, sir?
With with the bond, yeah, that'll all be discussed as part of the tether condition. Because this time, 2 months, I think, this will be 10 days, it'll be like 15 days, and by the time that happens. I was hoping that would count for something, as far as the conditions of my bond. And big, yeah, I can't afford cash bonds or something, just write a PR on them, maybe sign that, got it, you know.
I don't know what you're asking me.
If the tether situation could be addressed on the same day.
I'm going to address everything on any day that you appear. So if the tether is part of the condition of your bond, which at this point you're in violation of, I've set a hearing for the 16th to determine whether or not there was a violation. But the allegations are there that there was a violation. The following week, you're set for preliminary examination on the charges. Okay, so all right. I'm going to assume that there's nothing else. Bond will remain revoked. Thank you.
And just like that, the gavel comes down, but this case is far from over. Here's the big picture. Cody Lee faces 2 counts of criminal sexual conduct. He insists on representing himself. He's violated bond conditions. He's admitted to trespassing at a university he was banned from. And now he's facing a separate hearing that could keep him in jail until trial. Judge Simpson has been patient, but firm. He's issued multiple warnings, clarified every right, and offered chances to request legal aid. But Cody keeps rolling the dice, betting on his own ability to outmaneuver the system. Whether that gamble pays off remains to be seen. But one thing's for sure, this courtroom saga is packed with tension, legal twists, and personal recklessness. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.